operating from the additional place of business, which is the subject matter of consideration in the writ petition, Your Lordship.
Your Lordship, as your Lordship knows, it is a civil dispute between father and son, Your Lordship. Son is the landowner and father is the tenant, Your Lordship. Okay. And they are utilizing our machinery for eviction, Your Lordship, of the father, eviction of the father, Your Lordship.
So let them.
Your Lordship.
That's a personal dispute.
Your Lordship. So now we have cancelled the registration. Your Lordship, what happened?
Cancelled means what?
The background.
The internal matter. You have.
He is the opposite party. He is the opposite party in the writ petition. He is the opposite party, number 3 in the writ petition.
Correct.
And the petition.
He is the son.
He is the son. He is the landowner. Your Lordship, initially we have granted the registration, Your Lordship, and the disputed place is additional place of business. Your Lordship, after consideration of the objection of the son, we have cancelled the rejection.
How can you? There is a landlord
Exactly.
dispute.
Exactly, Your Lordship.
So long he is not the father is not evicted physically.
Your Lordship.
He has every right to utilize the property. He cannot be.
That is the dispute, and also Punjab and Haryana High Court the same view as
judgment.
Your Lordship. Your Lordship's own judgment. Punjab and Haryana High Court the same judgment, and it is against the department. Your Lordship's interim order is that to grant provisional registration certificate
at the principal
place of business. Your Lordship, there is no provision. There is no back office. In the back office, there is no system only to grant the registration. For that reason, we have issued the letter on dated 3rd April to the business, to the petitioner in the writ petition. Your Lordship, that in obedience to the direction of Honorable High Court, Your Lordship, there is no such provision in provisional registration certificate in GST back office portal.
Give a full-fledged certificate.
Your Lordship, we have granted.
Yeah. You have granted.
No, Your Lordship, we have granted. We have revoked the registration.
Why?
Temporary. Your Lordship's only
granted for permanent one.
Not to him.
To the petitioner. Not to him, but to the father.
Your Lordship, now even for this temporary registration, he is filing contempt against me.
The
opposite by number 3, who is filing counter there.
What
is a violation?
It is in violation of Your Lordship's interim order. Your Lordship directed.
We say that the department is directed to provisionally issue GST certificate at the principal place of business.
Yes, Your Lordship, where there does not appear to be any dispute.
Whatever, there may be a dispute between father and son. It does not mean they have to grant a provisional certificate. Have they granted a certificate permanent?
No, permanent.
Since provisional you have given?
Your Lordship. And Your Lordship, as an officer of the court, I found this judgment of Punjab and Haryana High Court identical to the case of the petitioner.
So why you are traveling?
Against the
revenue of kilometer.
So you
have a 400 kilometer.
Your Lordship, it is the identical circumstances. So far, the additional place of business, it is not required to verify any document.
Your Lordship, may kindly glance.
File the counter on the original writ.
Originally, the dispute does not relate to father and son, Your Lordship. There was a lease agreement between the landowner and a company that the director is the father.
Whatever be, the father remained in possession even after expiry of lease.
No, Your Lordship, that is not the case at all.
They are found in possession.
There was a lease agreement, and the lease agreement had a condition that it has not to be sublet to any further.
Madam, you are before a civil judge. The difficulty is, I'm telling, if a lease is granted, lease is for a duration. Correct?
Yes, Your Lordship.
Suppose the duration is over, the lease expires. That does not mean that the lessee has to immediately, though under section 108 of the Transfer of Property Act, it is an obligation of the lessee to hand over the possession. Suppose if he does not, then he'll have to go for a civil suit and get the eviction from him.
That is
correct. So long he is in possession, he can enjoy. You can seek for a
Your Lordship.
advisory jurisdiction, mean profit.
Your Lordship, with great humility here.
Provisional GST certificate.
Your Lordship, there is no provision to issue any GST provisional certificate. Only we have revoked the certificate and we have instructed them to operate in the principal place of business. Even Your Lordship, we are in so much of trouble, our authority.
No, I just wanted, have you issued a GST certificate at the principal place of business?
Your Lordship, because we cannot.
I am asking, I'm asking you a very simple yes
Your Lordship,
or no.
Your Lordship, we have originally the registration certificate.
I am again asking a very specific question. Have you granted the GST certificate at the principal place of business?
We have granted.
Where is that?
That's all.
Your Lordship, we have revoked that certificate.
Mr.
Sorry?
Counsel, the order is very clear. Please see the order. Order
Your
number
Lordship,
2.
Your Lordship.
If you have any grievance against the order, you could have filed an application to revoke that order, to modify that order. The order is specific. You are to issue the provisionally issue that GST certificate. We are putting a question that whether you have issued or not. So if you have got any problem, you are to file an application to modify that order. You have not done so, that contempt lies against you.
Your Lordship, we have temporarily, in obedience to the direction of the second page, Your Lordship.
Sir, I am asking you a very specific question. Have you granted a provisional or permanent GST certificate at the principal place of business or not? Yes.
Your Lordship, the certificate, principal place of business, we have granted.
Granted, we wanted that. We will record that you have granted at the principal place of business.
You are not sure, or we think that you are not sure.
No, Your Lordship.
Now you say that
Your
has
Lordship,
been revoked. Now you are making another statement.
that
Produce that certificate.
that registration certificate, which was originally, that has been revoked, Your Lordship. Because provisionally we cannot grant, Your Lordship.
Sir, again I am saying,
Your Lordship.
if there is no provision for a provisional certificate, you are bound to issue a permanent certificate or a perennial. Have you granted a permanent certificate at the principal place of business? I am asking you.
Your Lordship.
I can understand. We will. Tell me whether you have granted
Your
to
Lordship,
at the principal place of business.
that original certificate we have revoked, means granted, Your Lordship. That means, Your Lordship, because
To contempt notice.
Your Lordship, I may
Now, when you are not sure,
this is the registration certificate,
Sorry.
Your Lordship.
I
Original,
am asking you, Mr.
we have
Mishra.
granted, Your Lordship.
Don't
You are not sure.
you don't say anything which is ambiguous. I am asking you a very specific question, expecting an answer in a very specific manner. Tell us straight away. There is an order
Your Lordship.
directing you to issue a provisional GST certificate at the principal place of business. Have you granted a provisional certificate or a permanent certificate? Tell me, at the principal place of business.
Because if you would have any difficulty that he is not entitled to, or whatever it may be,
Your Lordship.
you could have filed an application to modify that order, to recall that order. You have not done, so he has rightly filed an application for contempt.
Your
The
Lordship.
order produce there.
Your Lordship, we have granted, Your Lordship. I may be permitted
Produce
to-
that order. That you want time, or you are having with that. My lord is asking you that very
Your
question.
Lordship, at page 2, I have submitted, Your Lordship, page 2, Your Lordship, pursuant to this order, We have issued this, Your Lordship.
Where is that?
Page 2, second page, Your Lordship. The first page, order of revocation of the cancellation of registration. This is reference to your
Have you
Lordship.
handed over a copy to ma'am?
Your Lordship. The second page, Your Lordship. So his original certificate is this,
Just
Your
a
Lordship.
minute.
That is read annexure page annexure 2, page 25. In the read petition, he has enclosed the RC registration certificate.
Have you issued the certificate to Anand Hypermarket?
Your Lordship.
Where
This is Anand Hypermarket, Your Lordship. This
I'm
letter.
asking where
Page 2, Your Lordship.
place to
Your
what
Lordship. And page
place?
25.
Yes,
Annexure 2, page 25 of the read petition.
correct.
And this order of revocation, page 2 of my instruction, Your Lordship.
Sir, the difficulty is the difficulty. No, no, I understand. Then permanent.
The registration has been issued. That has been cancelled.
Sir, the dispute as it appears from the earlier portion of the order is
Your
that the father has submitted the premises without
Yes,
any
Your Lordship.
permission.
Your Lordship.
Now the application for GST was
Cancel.
I think the revocation was done because the son has given an objection to the authority.
Yes, Your Lordship.
No,
We have
Your-
said
It was
No, Your
cancelled
Lordship. No,
because
Your
of my
that
objection.
no will not do. Come to the order of 2nd of April. Come to the order.
Your Lordship.
Paragraph 2. I am reading for you.
Your Lordship.
The cancellation of the GST certificate is basically founded on the alleged fraud, misrepresentation, or suppression of facts. The facts discerned from the record reveals that the petitioner, the partnership firm, applied for an additional place of business on the strength of a sublease
Mile.
executed by the admitted lessee of the premises with the sublessee.
My Lord.
The lesser raised an objection before the authority that sublease is created in violation of one of the terms and conditions embodied in the parent lease,
Your Lordship.
which appears to have been projected as a complete embargo in continuing with the GST registration.
Mile.
The pivotal issue involved in the instant writ petition, though not directly, but incidentally arise, is whether the authority can adjudicate as to whether a deed of lease executed between a lessee and a sublessee
Mile.
is an outcome of fraud, misrepresentation, misstatement, and or suppression of fact solely on the basis of the restrictive clause contained in the parent lease.
Your Lordship.
The learned counsel for the department seeks accommodation. Then we pass, since we have found a prima facie case
Your
and
Lordship.
made out,
Your Lordship.
department is directed to provisionally issue GST certificate at the principal place of business where there appears to be no dispute.
Your Lordship.
Why you are not issued a principal place of business?
Your Lordship, the cancellation, Your Lordship, I may be permitted. The cancellation has been challenged, Your Lordship.
Yes,
Your Lordship, I'm sorry, Your Lordship, I may take
yes,
Your Lordship, I may be permitted to
this-
take
the
instance.
instant contempt application is taken up. Petition, sir.
It is connected, Your Lordship.
This
Today.
bench is not in session of the contempt, the writ petition.
Sir. Obliged, Your
It's
Lordship.
only contempt.
For orders item 1,
Under the petition.
The typographical error. The matter is listed today at the instance of the department, pointing out the ministerial end of the
item number 3,
application for condonation dismissed for the board. Consequently, since the advocate in record of the
Law 4.
May please, Your Lordships. In this matter, Your Lordships, I have challenged.
Caveat is there.
Pardon?
Caveat is there.
No, Your Lordships.
No caveat.
You are not checking up the list. Cause list you have not checked up.
I have not given copy to caveat, Your Lordship.
There is already a caveat is there.
I have not given copy
Then
to.
have you seen the list?
Yes, Your Lordships.
You have to serve.
Yes, Your Lordships. I'll serve.
There is already.
It's 6.5.
Item 5.
Sorry.
He wanted to furnish a the main is whether there is any provision for the same or not in the tender notice or in the statutory rules.
Rule is there. It says that it will be deputed only.
It should be a cash deposit or it can be done by a bank guarantee.
By back guarantee, there is no any provision.
Correct. So, who is the advocate in record?
Under OPWD. Under OPWD.
No. That is
Mining.
Mine.
wait,
Indian Constitution details.
OMC matter.
OMFC rules.
27 देखे 27 देखे OMMC rule 27
But there is no Petition. Where is Mr. Bhuya?
तो Sikandar
This Jagseri. Say touch, perhaps. Say touch, you might. It is. Law of 9 study. Nanto Kumar Dolai. RAMAN Swine. He's talking about amendment has been brought into a 2016 rules. No? 37. It does not.
Bank guarantees rules, Lordship.
Under what provision?
In fact, Lordship, there is no specification that either to give Lordship in cash or
But-
bank guarantee.
But that
But
is what
speaks-
is what was the tender condition?
Tender condition, there is no Lordship. There is
What
no.
are you talking? Show us the tender condition. The
Yes.
security deposit is to be done. to us.
If Lordship kindly see page 34,
34.
Lordship. So for the eligibility criteria is concerned, Lordship,
No, I am just talking about the security deposit. You just
security for bank, Lordship, so
Where
Lordship,
is
kindly
the provision for
4.2 Roman 2, Lordship, 27.7, Lordship. Only 27.7.
Sir, I am conscious it does not talk about, but what is the tender conditions where the
Tender
security-
condition, Lordship, kindly come to page 34.
4.2 you are relying upon.
Lordship, 42
4.2.
Roman 2, Lordship.
Yes.
The bidder shall submit either income tax return or previous financial year certified by chartered accountant showing annual income or an amount of less than amount of minimum
Sir,
additional
where is a provision for deposit of the security amount?
Lordship, Lordship, I'm coming to just 2 lines below, Lordship. The minimum guaranteed quantity for the whole year, submit a bank guarantee validity, a bank guarantee valid for a period of 8 months. Lordship, 8 months for the amount not less than amount such and such, Lordship.
What is this?
18 months, Lordship.
Page 24.
Lordship.
So the way which page you refer.
34, page 34.
Pursuant to rule 27.4a.
For Lordship, that's bank guarantee is permissible, Lordship. But 27.7 is neither saying about bank guarantee or Lordship cash. Only say
Mr. Dodi,
Lordship.
clause 4.2
Lordship.
speaks about sub-rule 4 capital A.
Lordship.
When was it introduced? It is not available in this book.
No, Lordship, that is also 27.
27 amount it says. It not say
Lordship.
See, this is the reproduction of 27.7. What page for? This is absolute. The page
Rule
40
27.7.
A is a replica of 27.7.
Lordship.
Now, there are two words which are appearing, which
Lordship.
troubles me.
Lordship.
First expression is to deposit an amount.
Yes.
And the last expression is interest-free security deposit. Now, when these two expressions are to be considered, what does it convey? Bank guarantee cannot be an interest-free. Can it be?
Interest-free Lordship of bank.
Can't
Bank
be.
guarantors.
Cannot
Bank.
be.
Then what is the meaning of the word interest-free?
Lordship, by this, Lordship, they will take that
No, no, no.
interest, but here the
Sir,
bank.
bank guarantee means the money is lying with the bank.
Bank,
And the
yes.
bank stood as a guarantor for that amount, that in the event any invocation is done, they will remit the amount to them.
Them,
That's the
Lordship.
only guarantee.
Only guarantee, Lordship.
But so far as the deposit is concerned,
Deposit consular, they will take
Then-
that interest, Lordship.
and
That is
then
only.
B will not be applicable. It says
No.
the security deposit liable to be refunded after the completion of the lease period. How they will refund? They will only release the bank guarantee, then nothing more than that.
No, this deposit is already made, Lordship. This B, that is already made.
What?
Lordship, the secure deposits liable for refunded after the completion of the lease period.
Alright, that is first
That-
clause is, sir, A and B has to be read together.
Together, that's
A says to be deposited, which will be an interest-free security deposit.
Lordship.
Means that amount would remain with them.
With them.
B says that if you complete the period, they will refund it to you.
Lordship, B is Lordship, in fact, in Procedural 27(4), which is only been deposited during participation.
No,
That will
sir.
Yes, sir, Lordship. B, Lordship, kindly see Rule 27(7). There is no B.
Sir, 27(4) does not.
4,
Sir,
Lordship.
that this B is a
Lordship.
situation
Lordship.
after 6, 27(6).
Lordship, kindly see 27(4)(3), Roman 3, Lordship.
Please read that.
Lordship.
Mr. Doloi,
Lordship.
you are a veteran lawyer.
Lordship, in fact, Lordship, it is
You know the consequences, the implication of law.
no, here, Lordship, it is
Do not argue something.
No, Lordship.
Sir, what is the meaning of this word?
Lordship.
The security deposit liable to be refunded after
Lordship.
the completion of a lease period, subject to the condition
Lordship.
that the lessee has fulfilled all conditions of the lease,
Lordship.
and in case of violation of any of the terms and conditions of the lease, the security deposit shall be forfeited in whole or in part by the competent authority. What does it mean? This is a situation after the lease is executed in your favor. When can a lease be executed? 27(6), when you are a successful bidder.
Lordship.
Then 27(7), your concurrence and acceptance to the terms and conditions, and then the deposit of the security amount.
Lordship.
Then B. How can it be at the
No.
time of submitting the bid?
Lordship, my humble submission for Lordship. Here, Lordship, we are not Lordship. In fact, Lord, I am not disputing. If they will say deposit, Lordship. If
Deposit?
Lordship,
You can't.
because Lordship, only I pray, Lordship, they have now given us 7 days time. Lordship, kindly, only I will pray, Lordship, because my client today, Lordship, left for UK, Lordship. Will by 10 days, you will come back, Lordship. And Lord, 7 days,
It's up to them.
the Lordship, they will
They
take.
extend, they extend.
Lordship, with that such observation,
No observation.
then Lordship, let I over Lordship, I will try my next week. I will, in the meantime, I will try to
I will
deposit.
take instructions.
Lordship.
Instruction. If you can,
Lordship.
considering this aspect,
Lordship.
you have extended for 7 days.
Yes, sir.
The power is there, unlimited. If you extend it for further period, whatever.
Gratitude.
We are not keeping anything.
Oh,
We are
man.
simply keeping this matter on the next Thursday.
Lordship.
Adjourn
Well.
next Thursday.
Item number 6.
Before I take finals to the matter involved here, by and large, this matter is contingent upon an order to be passed by my lords in WPC one of the reserved by my lords.
Which one is reserved?
That is
Matter which I was just to assist my learned supplement my learned friend's submissions. I was arguing that matter Indian Oil published. They did not
the
release.
release of those tankers.
They did not release those 2 tankers.
Oh, these 2 tankers.
Right.
Oh, this is
was reserved
reserved for judgment.
Reserved for judgment. Got some additional citations also. Your Lordship,
Give it to me. No. Give it to me. Let us see if I.
One the small solution. In the meantime, I have some additional notes.
Now I understand that was a case where the two tankers of a lesser the capacity was sought to be replaced by two tanker of a recent make of a higher capacity. They say that since you have already quoted in another tender, there is a fraud which you have utilized or used that particular tanker for another purposes. That's why you are liable. You were penalized for that. There you have given a letter, if I correctly remember, that you please give me a no objection that release it because I want to participate in another tender and I will show these tanker to be used there. But the fact remains the tankers are still used by the government. I understand.
But in fact, he had me for one and same client.
Same claim. Because I need to determine the outcome of my client's.
Now I correctly remember the facts.
But my imminent urgency here is now because I am not able to get it released from them. I am not able to produce it here. Now on the ground of NOC, they are cancelling my
It's a Palace case. I think Mr. Srinivas Patnaik.
No,
Mr. Satya.
Satya.
Okay.
You just give it to me today. I will dictate
So
it. Come on Monday. I will.
Monday, along with this matter.
Yes.
Let
We will be delivering a judgment there. Don't worry.
Not this thing. That's the problem in this matter.
Only Monday, sir. Monday, nothing is going to happen. With that matter, that is why it will be suspended immediately.
Item 7.
You have given additional arguments.
List of citations.
Give
Some more list of
citations.
Both are there. Both to one.
Yes.
May please.
Item 7.
Now here the petitioner was licensed by IMFL ops of 2016 and 17.
Whenever you appear, I always presume it must be online or off shop. Off or on. That's the only thing.
Yeah, that's
Yes.
the matter. Here, my lord, what has happened? The 2016 and 17, I was licensed. There is, my lord, public objection was there, and my lord, the public forcibly locked the shop room. And my lord, that after 4 years, 2020, I was issued a demand notice that I have challenged before this honorable court. And this honorable court directed.
Did you intimate them that the public has locked it?
Yes, yes. No, that is there. I have intimated, I have lost the affair against 41 persons. There are 41 persons are there, they locked the shop. So I intimated, I lost the affair also. So there is also, the collector has directed inquiry and collector has found that the shop was closed. But ultimately, after 4 years, I was issued with a demand notice. So I filed writ petition and this honorable court directed the state government to consider my representation in accordance with law by giving an opportunity of hearing and pass a reasoned order. That order has been passed 2021. I was not communicated. Now 25 after 4 years, they are not communicating that decision. Decision has been made on some other facts, not in my facts.
Have they communicated to you the order which they
No, Lord. That I got on the right RTA. Now I have filed. After getting now they have issued. I have taken instruction. Now they have issued a letter directing that to initiate certificate proceeding against me. Then nothing has been decided against me, and they have issued certificate proceeding.
Decided. It has been decided against you, but the order is not communicated.
Not communicated, and I got the on the RTA. Now I have found that there is
next Thursday you take instruction and come back.
I have taken instruction.
Take instruction. On his plate, take instruction next Thursday.
Item 8.
Not to take any coercive action because no certificate officer.
Certificate proceeding, certificate officer will issue a further show cause. Things are to go. It will not.
That's right.
Item number 8.
Wait, please. It's item number 8. The present petitioner here present petitioner is a bidder who has participated in the bid floated by the NSE, where the clause of financial bid that has been under challenge on the ground, that this particular
you participated. Now you are challenging.
After the participation, before the opening of the technical as well as the financial bid, the petitioner has brought to the notice of the tendering authority about the particular grievance of the petitioner, which is confining to only the selection criteria of the financial bid. That particular objection was well raised before.
That selection criteria was uploaded at the time of the tender.
It was, my lords.
So you participated with your open eyes.
Yes.
You did not raise an objection. Immediately you should have raised an objection or challenged the sender notice that this
My lord.
clause is either onerous,
My lords.
unreasonable,
My lords. My lords, I challenge.
and the financial bid was open.
Financial bid was open, but
You were not the L1 or H1.
my lords, so far as the technical is concerned, we all secured the same mark.
That is, I am not concerned. In a financial bid, you are neither L1 or H1. I do not know the nature.
Yes, my lords, in the financial bid, all of them, my lords, quoted the same price for which lottery procedure was adopted.
So lottery, you could not. You are not a lucky one.
That is not the case, my lords. That is, we are not the lucky one.
You are not.
Whereas the case of the, I'm conscious of the limitations.
And now,
the difficulty, lordship, is that the objection was raised at the very first instance after, before the opening of the technical bid. The objection was raised specifically saying that these two conditions were there in the first tender, which got cancelled abruptly. The first tender had a stipulation. We participated, that it got cancelled. After the cancellation,
where are the judgments that after participation?
Lordship, there are lots of judgments that I have not.
VK Verma, or there are
Yes,
any
Lordship,
other
I can
give one or two judgments.
kindly pass
That is
on
what-
or lots of get an judgments of own High Court, Lordship. After participation and Supreme Court judgment, Lordship. He can, Lordship. Kindly one pass over, Lordship. I'll do all the same.
I'm conscious of that fact, but the only ground which I'm
maybe the conditions are not onerous. I am saying is onerous, but can you take
the timing of the raising objection is
you can't. You
That
can't touch upon the conditions. If they have violated a condition, you can definitely come forward and say that this condition has been violated. But if you cannot say this condition is bad.
So I'm conscious of
distinction.
I'm conscious of the limitation that I'm going through.
Then sorry, we can't.
So only
Just no, Lordship.
So
I'll pass.
Just 5 minutes, I will dictate.
Within 5 minutes, Lordship.
Yes.
Item 9.
Yes, sir.
Item 9, my lord. Item 9. We are filed. I am for the Odisha Forest Development Corporation. We are filed a caveat yesterday.
My lord,
who is for the petitioner?
my lord, I am for the petitioner.
Yes. You wanted to quash annexure 4 and 5.
Lordship, may please pay annexure 3. That is the Odisha Forest Development Corporation, my lord. They floated a tender for purchase of kendu leaves for whole period of 2000.
Purchase of
kendu leaves in Odisha for financial 2000. Kendu leaves.
Okay.
For the financial year 2025-26.
Tobacco leaves.
No.
Right.
It is
Okay.
Lordship, please peruse annexure 3, page 20. 31st May 2025, they published this notice having different dates for sale of kendu leaves. The third, my lord, column 3 is that is the e-tender and e-auction has been made on 28 2025. My lord, they have not appeared. They have not filed any bid also.
One caveat, my lord.
Now my lord, the state government has been served copy. State government has been served copy, and if one senior wants, my lord, I can serve a copy, maybe taken up tomorrow. Today I can serve. Here what has happened? They have published, and their own terms condition says that it is going for e-tender and e-auction. Next page, my lord, annexure 4.
No, I said they say that in e-auction they could not sell the entire crop or the entire product produced. So they wanted to sell it again by a manual.
My lord, that is there. How they can go for beyond the terms condition which they publish?
You participate
My
there.
lord, how can I participate? My lord, I am an outsider. I am an
We are
outsider.
already-
Only the fairness and my lord, the thing is that it's because local tender they are creating problem for which e-tender was called. Last year also same thing happened for which e-tender was called also. It is decided by the of this corporation and their own annexure, annexure 1, page 11, the terms concern clearly says that is 8/7/2025 they publish it saying that it will go for e-tender for the Kendu leaves. That's it. Please peruse the annexure 1, page 11, what they have written and the condition they have put it.
No, they say that it should be done in a, they will do an e-tender.
Yes, madam. I am on that only. They have changed it to manual tender now.
So
That they have changed it.
where
The mode has been changed.
that is that this tender was complete in all respect, but the entire lot could not be sold in the e-tender.
Well, that is not there in the.
Sir, the language of letter annexure 4, the first one,
my lord,
it says this is for information to all concerned that the sale of fresh,
my lord,
/ unsold and resale Kendu leaves, lots of 25 and area crop year,
my lord,
will be held through manual auction area.
My lord,
because they could not sell it.
My lord, they sell it. My lord, on 20th/8/2025, first e-tender was conducted as for the annexure 3, and I was the highest bidder, and I have paid also. Then subsequently, they have.
Sir, you are successful bidder in some kind of a lots.
My lord,
they are selling in lots.
My lord,
have you been adjudged as a successful bidder in the entire lot?
Not. I am not on that. I am not on that. I am only saying is that it's because they have published for e-tender in e-auction.
So your tender is already accepted.
First
purchase.
First that I purchased.
Yes,
second miler on 22nd/9/2025, the tender was there. They are changing it to manual.
Where is a mandate that they cannot do it in a manual manner?
My lord, the lordship see the annexure 1 that they
annexure 1 is what they say. If the tendering authority has a right to float the tender with certain conditions, they have a right to modify the terms of the conditions before the entire thing is done. In between, they cannot.
Yes, madam.
But subsequent they do.
Madam, on 31st May 2025, they call for the tender for whole period of the financial year. Different dates has been provided.
But there was no successful tenderer there.
Madam, I just let's see the annexure.
Only for some lots.
Some lots.
The remaining lots.
Remaining lots are there. Why they are not going for the tender, going for the manual tender? That is the reason. They changed it the mode. Why they have changed the mode?
Why you are afraid of not participating?
My lord, it is in the local bidders. It's difficult for us as from Calcutta I will come and participate here, and there is a threatening is there. That's why.
Threatening. Have you lost any?
No, my lord.
Last year, lost any?
Last year, my lord.
Last done so.
Last year there was setting. That's why.
Have you lost any FIR last year?
Last year, my lord, there was.
Have you lost?
No, I have not lost.
Then
I am not.
Mere saying will do.
I am aware of that, my lord. Only one thing I am to brought to the lordship that is because they are changing the mode.
No, they are not changing, sir. This is really, though they say in partial modification.
Yes.
But their intention is that unsold lots.
Unsold lot of the
they wanted to have it a manual auction.
Manual auction, my lord. I am ready to participate. There is no issue. But e-auction will be better than the manual auction because
your contention.
Then others will be participate from that.
Many are not participating, then what can be done?
No.
After all, these are all they have a self life. It's a perishable goods.
Yes, my lord.
They cannot keep it eternally. They have to sell it.
I am ready to, my lord, participate. Let me allow me to participate through the mail, my lord.
My lord, I am appealing for the opinion of 3.
Mr. Counsel, how can you change?
That is,
let us see.
Because
Annexure 3 itself may be seen.
How
Annexure
can you
3.
how can you change it? Annexure 4, the very first sentence.
No. My lord, see, am I audible or not? I am for opening number 3.
Audible and visible both, sir.
My lord, that my lord, see annexure 3 again. 3
Please.
itself.
Yes.
S20, my lord.
First sale was June 25.
What?
First sale was meant to be an e-tender in June 25. In
Correct.
June.
Correct.
But that that sale was done to manually. This first sale was done manually.
Why?
My
When
lord,
it is an e-tender, then why?
We have the power. We don't have that.
There is a power.
We cannot do it.
Can you show me a power?
My lord, see that annexure 3 last line. Last
Yes.
line annexure 3.
Correct.
Modification of sale schedule, if any, will be notified separately. So
What?
this June sale was done manually, and he participated. Petitioner participated in that. My friend in the caveat petition, I filed those documents.
So, what is the meaning of the word? It talks about the sale schedule, and the sale schedule is really a date on which those sale would be effected. It does not mean that the entire, I would say, the procedure for the sale would be changed.
My lord, procedure is open. There is no restriction. My lord observed, there is no restriction to do it only on e-tender.
No, don't go. Sir, don't go by the observation of the bench. It is only in order to understand the correct proposition. Don't go.
All right, my lord, see.
And look at Annexure 4, sir. Look at Annexure 4.
My lord.
First line, sir.
My lord.
You are partially modifying that particular sale notice.
My lord.
E-tender.
Yes. What happened, my lord? In June itself, there is a manual.
The schedule that auction instead of say 1st of January may be held on 7th of January. No difficulty.
Well,
you can the schedule. But
my
can you
associate court will hand over the document to you. My associate court may hand over the documents.
Please. What document? No. This is what is already they have annexed.
No, not my lord.
No, not annexed. But these are suppressed. They have this fact.
Which one? They have participated in manual tender.
June.
In June.
Yes.
He participated in the manual sale. He got the orders in 50 lakhs.
First schedule.
This was his fourth one, my lord. Fourth is that is 9/2025. Third sale.
Before that, there are 3 sales. One in June, July, and August. In June, he participated in the manual sale.
First one.
First one.
Mini sale.
Manual.
Mini sale, manual sale. That is the manual sale.
Manual sale.
Manual sale, he got some lots.
E-tender, but they have shifted to the manual.
Manual sale in first sale itself. 10th June notice.
With deepest of respect, sir, have you seen that 10th June this notification?
My lord, yes, I am holding it.
Please read, sir. Tell
in
me.
Partial modification of the notification dated. Right. In partial modification to the notification dated 31/5/2025. This is for information to all concerned that mini sale through e-tender fixed on.
Tender. Please remember this. E-tender. Remember.
Is rescheduled. Is rescheduled as a manual auction sale at Sambalpur. I will commence from 23rd June 25. This
has he participated? Has he participated therein?
Yes, participated and he has got the purchase order also. And the next annexure.
This is on 23/6/2025.
My lord, he participated.
He participated, and he was successful or not?
Yes, successful. Got paid 50 lakhs. Strong 50 lakhs. The next document, next document. He participated.
My lord, I have no knowledge.
Then my lord,
if that being the position, sir. No, sir.
That's it.
Bring it by a short affidavit of 2 pages. bring this.
Be called for me. I filed a caveat 1382-2025. Caveat 1382-25 may be
The charm in recording the caveat, sir. You are appearing, your name is recorded to have reported. What more, sir? You are a senior advocate, sir. You know. There's nothing. Yeah. Yes. File it.
Item number 10.
Order passed by the Commissioner of Commercial Taxes, my lords, during the pendency of the second appeal under the provisions of Section 17(7) of the Odisha Entry Tax Act, my lords. Here, my lords, if your lordship would kindly turn to Annexure 4 at page 37, my lords. And if your lordship would turn over the page at page 38. One of my principal and specific submissions, my lord, is submission number 5, where I've said that the
Revisional part. Revisional part. Revisional part.
Entry Tax Act, if your lordship may kindly turn to 70.
High Court.
No, it's not an appeal, my lords. It's a revision pending second appeal.
Against the
Pending
order.
second appeal.
Second appeal, my lords. My second appeal is pending, my lords. It's 17-7, my lords.
At the time of stay.
At the time of stay, my lords. Since
The commissioner for the stay.
of Section 17, my lords, of the Odisha Entry Tax Act, 17 speaks of appeal to the tribunal. And if your lordship would kindly come to Section 17-7, subsection 7, where a dealer or person has preferred an appeal under subsection 1, the commissioner may stay realization either in part or in full the amount of tax or interest or penalty, as the case may be, remaining outstanding for recovery as a result of disposal of appeal under subsection 7 of section 17 on application in that behalf.
Where is there is no remedy provided against that.
No, my lords. There's no remedy. What has happened, my lord, so far as the VAT Act is.
Sir, during the pendency of second appeal, when you move for the commissioner, I think Commissioner of Commercial Taxes has issued one circular.
That is relating to the OVAT Act, my lords.
Under Entry Tax Act.
Entry Tax Act.
They have issued one circular. Commissioner issued one circular in tune with VAT, saying that you. I think Ms. Kajal will help you.
Not so far as this Odisha amendment.
That's internal communication.
Yes, yes. That is Commissioner's internal, internal communication. That this matter is dealt with by Commissioner herself.
Because so far as the OVAT.
How can she
reject this? And in 3 lines, she repeats my grounds of appeal. I'll collect that.
Have that.
Check. Learn and see.
So far as the OVAT Act is concerned, if your lordship would kindly come to the
statutory deposit.
20% of the tax.
Mr. Mishra, you should. Is there no letter to all?
So far as the entity tax.
Not to insist upon for the rest balance amount. The commissioner himself has issued a letter circular. It is
balance.
Sir, how this consideration can be said to be a proper application of mind? I have seen that particular provision that it is the
commissioner
which has been bestowed with the power to stay the realization, either in whole or in part.
The commissioner may stay realization.
Now, once that power is given, then there should be an application of mind. Simply because he find that the grounds are not a good ground for an appeal and do not find any appellate court's any error in the appellate court order. He will.
The main ground,
the demand has been reduced from 33 lakhs to 24 lakhs.
Can this be a ground for stay? Can this be a ground for stay? Refusal of stay?
The lordship will call it on Monday.
He has to record its independent finding that why he is not staying it. Simply because the appellate authority has reduced. That is a ground for refusal to pass stay.
And in an income tax matter, your lordship has said the reasons are the heart and soul of a case. Your lordship in particular case.
See, in that reason, you can't say there is bereft of reason.
He
has given a reason. But the reason may be appropriate, may not be appropriate. I am asking that only thing is that whether it is a due application of mind. He has given a reason that since the appellate authority has reduced the demand, so I am not staying. That may be a reason, which is correct, which may not be correct. But is it a due application of mind?
In
The meantime,
2015, VAT has brought out one amendment saying the statutory deposit during the pendency of second appeal, the rest amount shall remain stayed. Since at that time, entry tax was under consideration before the Honorable Supreme Court with regard to that virus matter 9 pages bench. So the department did not take it to
consideration.
this amendment. The similar amendment was not brought into force.
Your Lordship may call it on Monday.
So, Commissioner conscious about that thing has brought out, I think she has got.
Letter number 4508 by C.
Please,
Your Lordship may call it tomorrow, my lord, so I'll take out a copy.
I am more on a fundamental first principles of law. When a power is bestowed on an authority to grant a stay of the realization, then it is expected that he will apply, there must be an application of mind, why he wanted to refuse it, and can this be a ground? Because then the further provision of section 17 is absolutely a farcical one. What is the necessity of providing a further remedy of appeal? If the order of the appellate authority under section 16 is final, then there cannot be a further appeal provided under section 17. If it is not final, and if the commissioner can stay, then he has to record a reason, a proper reason.
17 is pending. Tribunal.
Under section 17(7). I think sometimes my wavelength of my mind is not matching.
Your Lordship, I'm sorry. I could not match your Lordship. It is my
No, my
deficiency.
incompetence, sir. My incompetence. I always treated my incompetence. When a authority has been bestowed with the power to grant stay, will he not record reasons relating to refusal and the proper reasons to be recorded?
Your Lordship.
He reported that these are the grounds, and these are not a good grounds for an appeal. Can he prejudge? He has no authority to prejudge. It's the tribunal who will consider whether the order of the appellate authority is justified or not.
The commissioner is the party before the tribunal.
So, absolutely non-application of mind.
And the issue raised, my lord, before, in the appeal as well as before the commissioner is already covered, my lord.
We are not going into the integrity of
the maintainability. No, so far as the prima facie case is concerned, your lordships have held that the sales tax officer in enforcement cannot be the head of the audit team. That's already settled by your lordship's court.
No.
That was what. That was my case before the commissioner. That was also my case before in the tribunal also as an additional ground. And now the commissioner says that it's not a valid ground.
How can he's prejudging. He's saying is evident from the submission of the dealer. The dealer has not raised any substantial ground against the appeal order under dispute. Means he is really exercising the power of a tribunal. He says that the appeal before the tribunal is absolutely not maintainable. Can he? How can he prejudge? Is he a tribunal? Then?
Let's see.
How can he record? How can he?
Both.
He could have put him on terms. I can very well appreciate that you can put on terms.
Your Lordship.
But it does not mean his finding is that the appeal before the tribunal is absolutely a bogus appeal. Can he?
Your Lordship may direct in balancing the revenue as well as the petitioner. Your Lordship.
We definitely we can put them on terms that half of the amount you should deposit and half as a security, whatever.
As your Lordship.
But that there should be some rationality in it.
So
There should be some kind of findings to be made.
Your Lordship may pass.
Your
I'll leave
Lordship,
it to your
sir, so far as Your Lordship may permit me to collect that letter. So far as the OVAT Act is concerned, Lord, on payment of 20% of the tax, the balance is stayed. Your Lordship, that's the amendment. Your Lordship, kindly see the amendment.
No amendment.
In OET, in the entry tax, no.
No, Your Lordship, kindly see the amendment.
No. Section
It-
17
Lord,
does not
34, Lord,
this.
Section 34 says, or Rule 34 of the OET Act says that if anything has not been provided for in the particular act or rules, then my Lord, your Lordship can borrow the provisions of the OVAT Act, my Lord. And what I've given, my Lord, is the 2017.
Where is the rule?
No, Rule 34, my Lord, your Lordship, of the Odisha Entry Tax Act. My Lord.
Rules 1999.
99 rules. Rule 34, my Lord.
24.
34, my Lord. 34.
That is true.
Implementation, my Lord. And so far as the appeal is concerned,
It talks about the expression is mutatis mutandis.
my Lord.
What does it mean?
It means, my Lord,
That every provision of the VAT Act or that would remain
uncovered.
Or it is only the principles which are
My Lord,
applicable, not the provisions.
with great respect, my Lord, why I say so? Because if a Lordship would kindly see Section 9B, it specifically says that whatever has not been provided for in this Act, the Odisha value-added tax will apply.
Sir, that is why I have looked into it. Says for any other matter not specified under these rules,
but required
for carrying out the
purpose of the Act and these rules, the provisions
under the VAT Act and the rules made there
shall mutatis mutandis apply.
Now, the word mutatis mutandis, what does it mean? I'm asking.
Not in my humble.
That means that with lock, stock, and barrel, the entire provision of the Act would be imbibed into this Act, or it is only the principles.
The principles. If your Lordship,
of the VAT,
if your Lordship put
provisions would apply. If the principles is something different, we can't say 20% will be the rule.
No, 20%, your Lordship would see that is brought by way of an amendment in 2017. I've given your Lordship the amendment. Your Lordship kindly peruse. And your Lordship would see the equity. If your Lordships are on equity as a 226 court
stuck with one or two judgments. That's why I'm asking you.
Your Lordship, for a moment.
Already on this point, I have already argued so far as the mutandis application, your Lordship, and so far as the substantive provision. When that provision 16.7.
So may I just produce that letter issued by the Commissioner specifically for OET Act notes, so that will at least help me, my Lord, to convince your Lordships that the Commissioner's level, at the Commissioner's level, they see these stay matters in a particular way, my Lords. If your Lordships are not with me regarding the amendment of the OVAT Act, my Lords, your Lordship may call it tomorrow, my Lord. I'll produce the letter so far as the OET Act is concerned, my Lords. That will be, my Lords, how your Lordship can look at it.
Or you will secure this amount or deposit?
Lords, whatever is the Commissioner's letter, I'll abide by that, my Lords. Whatever directions, my Lord. If it is 20%, I'll pay the 20%. I've already paid more than 10%, my Lord, of the amount by way of, my Lord, they have realized it in the first appeal, my Lords. So the balance 10% I can always pay, my Lords. Or if there is a letter of the Commissioner.
The internal letter will supersede the statute, the provision.
That means so there was no purpose, my Lord. That if the Commissioner says that she is not bound by her letter, I'm with great respect to my learned friend, my Lord. If the Commissioner says that I'm not bound by my own letter, then can the
Brother, I have a different view on this Rule 34.
this letter by tomorrow?
Cannot be applied. Cannot be applied.
And your lordship may see the prima facie case note. This honorable court has held that the sales tax officer cannot be the head of the audit team and quashed those orders, my lords. Here in this particular case, if your lordship kindly turn to page 22 of the audit visit report, the sales tax officer is the head of the audit team, my lords. And your lordships have specifically said, and that goes to the root of the matter, my lords, the jurisdiction, my lords. And your lordships have specifically said that this is a matter of jurisdiction in the other case, my lord, so far as Bharat Earth Movers case, my lords, your lordships have said that since the superstructure would fall if the foundation goes, my lord, and this is the foundation, my lords, the foundational fact to initiate a proceeding under Section 9. Your lordship may kindly see, my lords.
No, head of the
Your lordship will call it tomorrow.
But you are raising a very interesting question of law, which always
I'll try to
me and gives me a lot of encouragement to decide.
Lords.
And Rule 34, when you are applying, then I will definitely venture to decide that 34 what it
So
means.
if your lordships are satisfied about the commissioner's letter and its applicability to the Odisha Entry Tax Act, I need not go to Rule 34, my lords.
Just to avoid any future arguments to advance on 34.
So lordship may call it tomorrow, at least for the limited purpose of perusing the letter.
Now the statute is repealed.
Now the statute is repealed. May I pray for tomorrow, my lords? I'll produce that letter, my lords.
Item 14. Item number 14.
May I please, your lordship?
Your lordship, no copy has been served to me.
I'm sorry.
What this menial issue you are coming before the writ court? What? Are they not accepting your appeal?
Yes, my lord.
Why they are not accepting your appeal?
This shows that there is a delay.
So there is a delay. The statute provides for a limitation.
But
You
my
have
lord,
to, if they have a power to condone, you will have to apply for condonation.
but my lord, the petitioner has already paid the GST and the interest accrued on.
Reason matter. When there is a provision for an appeal and a limitation is provided, then you will have to follow. How can a mandamus of this nature can be? How a mandamus of this nature can be issued? Sir, I do not know. What is this?
No, he has already filed the appeal.
That is rejected.
That is high, your lordship.
Beyond time, so
Page 13, 14. That has been
64,
your lordship.
Page?
Yes, my lord.
63, 64.
Okay.
So after 2 years, you have come up before the appellate.
My lord, the facts of the case is there. The facts of the case is there.
So it is let him go to the private.
Out of cap as condemnable period vested with the appellate authority to condemn
Yes, my lord.
under 107 subsection 4.
Yes, my lord.
Beyond that, could he? You have come after 2 years.
My lord, the petitioner reasonably believes that his payment has been accepted by the authority.
After 2 years, when you come, whether he has got the, is it your case that you did not receive the assessment order or you did not have the knowledge about this, that demand?
My lord,
When have you come to know?
my lord, the petitioner came to know when his bank account is been attached.
No, that cannot be.
My lord, prior to it, the petitioner has already filed his GST and
There
the
is a petition for constitutional delay before the appellate authority.
my lord, is a 1 day delay and yes, my lord.
Where is your petition for constitutional delay
There
before
is
the appellate authority?
no
That
petition is there.
was already uploaded on 20th of April.
Knowledge. So I'm just calling out where is your petition for constitutional delay? From
My
there,
lord, there is no
can,
petition. There is no such petition.
because the appellate authority has recorded a finding that the delay was more than 2 years, 5 months, 8 days.
Yes, my lord.
So
The appellate authority recorded so, but the appellate authority, authority does not consider my my tax and the interest thereon filed.
unless delay is condoned, how can he?
Then I may be given a liberty to file a petition for condonation of delay.
It is not just like section 5 of the Limitation Act. There is no open end.
My lord,
Discretion, it is not wide discretion. It is limited discretion for another 30 days only. Specified period 90 days plus 30 days.
Yes.
Over.
My lord, the petitioner has already filed his tax and the interest accrued on. Much prior to the notice given under section 74, which has not been considered, and his bank account has been attached and revoked twice. That is first on 4 of February 25, attachment has been made. When the petitioner gives a letter showing the payment, the attachment has been revoked on the 14th of February 2025. Surprisingly, again on 19 February 25, bank account has been again attached, which is withdrawn on 1st of March. And there, however, the appeal is filed 27 February 2025. After knowing that there is a miscommunication between the authority and the petitioner.
Where is your petition for condonation? Where is that?
The payment. As it is filed on 19/4/2022. And thereafter, surprisingly, on 4th February 2025, his account has been attached. And thereafter, he came to know that there is a discrepancy and miscommunication between the authority and the petitioner. Thereafter, he files the. And in view of that, there is no limitation.
What is this? If he has already paid the demanded amount with the penalty, then
On 19/4/2022.
within the time.
Your Lordship.
We know the legal implication. There is no doubt about it.
But I am also just
Just be reasonable.
holding the brief, Your Lordship.
20
Be
in the
reasonable.
On 20th, Your Lordship, I'm just holding the brief. For that reason, I could not buy it. On 20th April 2022, page 55, the order has been passed. I have seen.
He has deposited the
Your Lordship.
entire amount within 6 days of the order.
Not entire amount.
Oh, full demanded tax and the
and
interest.
the
No,
interest.
no,
accrued
no, Your
thereon.
Lordship. That is not, he's,
Here
61
he's not 100% correct.
Please, page 61 come. Don't. Have you seen the reason for delay? The last one.
The reason for the delay, demand tax in stage 6 stage of the order of the document proper, whereas the proper officer not close demand from 26 4 2022 to
So 20th April and
that I'm
6
holding.
days he
That I'm
deposited.
holding.
That is what I am saying.
Your Lordship may kindly turn to page 37. The payment. I found from here he has made the payment,
Yes.
but not 100%, Your Lordship. She has made the payment of the tax as well as
So can you go for the entire demand or only the differential amount?
only differential.
Okay.
That I will verify, Your Lordship. Just now I have received the
entire
brief.
demand.
So far as the recovery I will verify, but so far as the appeal, Your Lordship,
What about 1819?
the appeal is accepted.
You have paid only the 1920. What about
I had already paid for both the financial years.
only the page 37 is 1920.
The petitioner is already paid the both the.
You have annexed the document which shows that is only 1920,
Yes, my lord.
not 1819. At page 37, it is for the period TGST and SGST 2019 to 2020. That's all. What about 1819? Because this order is also of 1819. No document.
Yes, my lord. I read it.
Take instruction coming the next week.
My lord.
Item 15.
Oh, bless me.
May I plead your lordship? Lordship, this is a matter for cancellation of RC, your lordship's order.
Yes.
16 sin. Item 16.
Both the matters.
Item 17.
Note 17 is regarding the non-constitution of GST.
Item 18.
Is also similar. Both the matters.
In the second matter, second item.
Item number 20.
20 million regarding multiple assessment here. What's I have given the cover. I would
And 81. No, let's know it like it was to be
So by
given.
then it is time for,
Sorry, ma'am.
see, for filing, 10% was to be deposited.
Yes.
At the time of filing, you did not deposit anything. So by the time you deposit, it is beyond 4 months.
Yes, no. I admittedly I deposited beyond 4 months,
Yeah.
but
they are also acknowledged it. They have also given the final number. And as per rule 1083 minutes, after the compliances is done, they have to give the final acknowledgement number. Moreover, minutes, when they gave me a PH, personal hearing minutes, at least I am entitled to a notice for which I could comply the pre-deposit thing. That is my humble submission, and in the means it's a paid. So
Central publication is So you deposited beyond 4 months. What can be done?
that's what I humbly submit. If this is a primary defect, they could have rejected
It's not
the
a primary defect. It really goes into the very root of the maintainability or
if they could,
acceptance of the
if
appeal.
they would have been rejected that then and there, then I would have time for further 1 month period minutes.
No, madam.
Minutes, one opportunity at least they could have issued a notice, because they have, if your lordship will see, the appeal 1 has been issued in which their acknowledgement is there.
The filing itself is barred.
Then how they gave the acknowledgement minutes?
Why did you then file in manual method?
Because manual method is also permitted, because as the order was passed manually, I filed the appeal manually. But I humbly pray, Millards, that as I have made the deposit, that the appeal be restored and heard the unknown merit, Millards. That is my humble prayer. And your lordship in similar circumstances has also passed the order, which has also been followed by other high courts also.
Other high courts?
Yes, that is at annexure 5, Millards. Page number, relevant page is page number 37.
No, this is annexure 5 is the Punjab and Haryana.
Yes, Millards.
So
Your lordship has gave the view on annexure 6, the similar order, and the same view has been followed by the Punjab Haryana High Court, where the Punjab Haryana High Court also held that as we hold that on account of the non-payment of the requisite fees, an appeal cannot be dismissed as non-maintainable. And in fact, before the appellate authority takes up the appeal, the appellant should be informed that any deficiency and be given a chance to deposit and remove the deficiency. And the at annexure 6, if your lordship will see your lordship's order, your lordship has taken the same view, Millards. So humbly I pray, Millards, as I have.
Doesn't this in us this part?
Pardon, Millards?
Article 226 doesn't rest on us this part.
But Millards, the
beyond the statutory, taxation laws have to be strictly construed and letters.
I bow down to that, Millards. But what I humbly submit is that the petitioner unnecessarily will be remediless, Millards, because they have summarily rejected my appeal. And even after
filing itself is barred by this. It is not like the earlier provisions.
If they would have,
when it was, you were to file for entertainment of appeal. Earlier it was there.
Why they entertained it?
But it is not.
That is a mistake of
filing. That is what Our court following Honorable Supreme Court judgment in IOCL, you must have seen filing and entertainment, 2 stages, isn't it?
Yes,
So
but
here it is filing.
Our judgment is different. No. Page 41.
Would you go by page 39?
No, 40.
No,
Page 41.
page 39. Would you say this order passed by this bench?
I have seen this, but
You would apply to
Have you come to page 41?
I have seen the
Page 41,
para 6.
para 6.
I have gone through this order, my lord.
Are you taking the similar stand?
Just one submission, my lord. The petitioner has paid much after 10 months of the
There
review.
also it was not. I am just asking you, are you going to take that same stand of paragraph 6?
Case when the payment was made, it was not mentioned. It is not mentioned.
Oh, please. You have not considered paragraph 6, please.
There we have not decided.
We have not decided. That's why I say paragraph 6.
That opportunity of removal of defect was not given.
You have not read paragraph 6. You
Sir,
are stuck up in paragraph 5.
It is your department.
My lord.
He was central GST. This matter was also central GST. So you are standing for central GST.
Yes, ma'am.
So your senior standing counsel made the statement at para 6.
Yes, my lord. I would say.
So are you taking the same stand?
As it was
Or undecided?
No. We have not decided actually. That's why I'm saying we simply on paragraph 6 it has gone.
Let me take instruction.
But take instructions.
Madam, this judgment is not a judgment on law.
I bow
It's
down.
a judgment on concession.
Yes, my lord.
So that's why I'm inviting that his counterpart in that judgment conceded. So will he concede?
Being remedialist, my lord, the petitioner does not have any other option because
Whatever there, the concession was there. So that's why I'm asking. If he concedes, we need not.
and if it pleases your lordship, that remedialist is the best ground to approach your lordship, my lords, because I have no other option.
No.
Yes, my lords.
There is a recent judgment of 2022-2023 on a different statute. If I correctly remember, is Baranagar Hospital or something like that. Yes. There, the decision was there also in order to maintain a particular proceeding. There was a condition of deposit of a certain amount. And it was held that if the power to condone the delay is not provided, then if you do not deposit, even if it has matured to a last stage, rejected. You are taking a plea since it was admitted, it was acknowledged, they have heard it on merit, they cannot do it. There also that was the apex court did not accept.
Instruction.
Come,
Instructions. Take instructions. Let us see. It is too harsh.
2 hours now. Yes. Next week.
That item 24, where the state government had taken time today, posting the matter today, Your Lordship, can it be tomorrow orders item 24? The tender matter, Your Lordship may recollect. Or it can be fixed any date in the next week under the.
No, 21 is over. 21 is over. Now, this is a fresh admission. 22. Tomorrow they complete.
That's the item.
20, give a fresh matter. Don't give a fresh matter tomorrow. Simply give those matters. From 22.
24, if I may pray.
22 to 23. There's 30. Yes.
And 24, that orders matters. Upon already.
Item 31.
Which one?
Item 22. Yesterday's possible.
Tally position.
Yesterday it was there. First of all, so today it was this.
What we are proposing is that tomorrow we will not list any new matters. From 22 onwards, the list will continue for the rest of them. We'll take up all the matters.
Let's say item 20.
At least one day we touch the whole of the matters.
27.
Pardon my lords, item 31, I believe mentioning was made by the petitioner. He wanted time today. I'm for the opposite party.
Which one?
Item 31, my lords.
So 31 after vacation.
My lords, my lords.
After vacation.
Lot 627 item on behalf of HN Mahapatra permit to withdraw.
Which one?
27.
27.
Withdrawal.
Yes. Allow the eye.
Let's say 2 matter are there.
Yes.
You can pardon me. So,
Both
item
the
13, Lord, I wanted to clarify. Can it be on Monday, subject to Lordship's kind convenience? Item 13. I was praying
You said tomorrow.
No, I said tomorrow, but I have a personal difficulty. I was just remembering about Monday minutes.
No. Then do one thing. Lease these matters first. And then the new matters, if it is there, then later.
13 on Monday.
Lords, with your lordship's convenience, if I may mention item 28, my lords, it's for withdrawal, my lords. May kindly allow the same. Yes, my lords.
Withdrawal.
Much obliged, my lords.
Then nothing left. So do one thing, whatever is left, you list first at the top, and then thereafter, any fresh matters you.
My lord, item 23 that relating to jurisdiction of education tribunal might be taken up for.
We are spilling over for tomorrow. Tomorrow we will do it.
Tally Suja matter.
The impugnatory charter, Annexure 1.
What is this? Writ petition by
Filed by the plaintiff petitioner.
Yes, for what?
I have filed a suit before the trial court.
Then why the writ petition?
At that time, writ petition was maintainable.
Now, why it is maintainable?
227.
Why it is maintainable? Writ petition under what provisions?
Under Article 227 of the Constitution, I filed.
So it is regarded as a writ petition.
Yes, Your Lordship. At that time.
227. Why not 115? You wanted to withdraw. So proviso is satisfied. If the order is set aside, that means the suit will come to an end.
Yes, Your Lordship. That's true. But here is the case, my lord. I made an application for withdrawal of the suit with the liberty to file the
application.
Application is under Annexure 1 at page
just
10.
Where is the order?
Order is under Annexure 3, Your Lordship, at page 13. The order starts at page 15 also.
Where is the difficulty? You wanted to withdraw because there is a cloud created over the title.
Yes, Your Lordship.
So
that is only.
Can it be a ground? Under Order 23, Rule 3, it says the fatal, that the suit must contain a fatal defect. Where is the fatal defect?
The documents.
Look at Order 23, Rule 3. What are the grounds for withdrawal?
Where it is proved to satisfaction that the court that the suit has been adjudged wholly or in part by any lawful agreement or compromise in writing the signed by the party, or where the defendant.
It is Order 23 Rule.
It should have been Order 23 Rule 1.
Correct.
It has
abandonment.
Yes.
Read.
At any time after the institution of the suit, the plaintiff may, against all or any of the defendants, abandon his suit or abandon the part of his claim, provided that the plaintiff is a minor or other person to whom the provision contained under Rule 1 to 14 of the Order 23 extended neither suit nor any part of the claim shall abandon without leave of the court.
Then leave.
2. An application to leave under the provision of Sub-Rule 1 shall be accompanied by the affidavit of the next friend, or also if the minor of or such other persons is represented to by a pleader, by a certificate of the pleader to effect that the abandonment proposed is, in his opinion, for the benefit of the minor and or such other person.
Yes. Then
where the court satisfied a suit must fail by reason for some formal defects, or that there are sufficient grounds for allowing the plaintiff to institute a fresh suit for the subject matter of the suit or part of the claim.
So where is the fatal defect, sir?
Well, in fact, admittedly, the suit has been filed for permanent injunction.
Sir, I understand.
Yes.
Can you not bring an amendment to convert it into a declaratory suit?
Yes,
because of the subsequent event, because you say that they have executed a sale deed.
Yes. That
can you not?
Yes, sir.
So
that we can.
Why the withdrawal? And that too after the cross-examination and everything has been done.
Here I wanted to, but some.
Can a court disallow the amendment because after allowing the amendment, it will exceed the pecuniary limit of the court? I don't think so. The law is very clear.
Last night I'll make an application for amendment.
This is up to you what to do and what not to do. This is the instant application under Article 227 of the Constitution. Yes.
On behalf of Mr. Picker Mishra, may I please, Lordship? Lordship, this matter arises from a judgment of 2008.
Yeah, how the revision lies?
This is a writ petition.
How the writ
Lordship.
petition lies?
Lordship, I am
Order
paying for
40 Rule 1 is an appointment of the receiver or refusal to appoint a receiver. Is it an appellable order or a revisable order? Yes.
Lordship, I am praying for an
I
adjournment.
am asking you the maintainability, madam. Is it an appellable order or a revisable order?
I am a pardon, Lordship.
Are you there in the matter?
No.
You are also briefed in the matter?
No, Lordship.
No. The Article 227 application? No. It is maintainable provided there is a manifest injustice apparent on the face of the record because of the alternative remedy, but it is an appellable order under Order 43 of the Code of Civil Procedure, and therefore does not come within the purpose. So we are rejecting this application as not maintainable.
Lordship, kindly
You
list
have a
this
remedy by
matter.
way of an appeal now. By this time, 17 years have passed. Exhaust the remedy of appeal.
Lordship, we have not received any instruction from the trial court decree.
Not necessary. It is not maintainable on the face of it. I believe order 43, Rule 1, S or T. S. The instant application under Article 227 of the Yes. Who is appearing?
In the suit for declaration, your maintainability part of was filed before Adesam versus Chavinat. So writ petition is not maintainable. Should have been 226.
What?
Writ petition is not maintainable. It was filed before Adesam versus Chavinat 2015 Supreme Court.
True.
So wrongly 226 is added here. So it's not maintainable. But fact remains that So Lordship will see the dispute lies in a very narrow compass.
No, is it a combined application under Article 226 and 227?
Yes.
Or it is a simple?
Usually we made mention of 2 articles, but then after that Radhesam versus Chavinash, it has to be confined to 227.
227 only. And after the amendment of 115 is Shiv Shakti Cooperative Judgment of the Supreme Court. Only 227.
220.
115 also does not lie.
Because it's an interlocutory order.
So what to do?
39.7.
It has to go. Not maintainable.
227 is maintainable. So, but the dispute before you, my lords, is very narrow.
Now conversion.
Very trivial issue.
No, conversion. You have made the judge as a party.
I need not convert.
Have you made a judge as a party in the proceeding?
No. Can't be made. That can't be.
226 when you are talking about?
No, that can't be made. That can't be made. Judge also cannot be made a party. Court cannot be made a party. Not today I am before my lord. This can be resolved before my lords also.
No, you have given a combined application.
That is not, that is usually being mentioned.
The bar and 2013, our High Court came up with that Supreme Court resolution. That from 2013 onwards, these will be nomenclature as CM. So prior to 2013, your lordship will find matters which were filed on the board.
No, I understand, because this is a writ petition which is really a unique for me, because I have been groomed in a system there where even in Article 227 applications are within the revisional jurisdiction of the High Court.
Yes.
So it is always regarded as a CR or a CO.
So that is because
like 115, the both are categorized as the civil orders or the civil rule. They call it.
That is because your lordship's High Court has the original jurisdiction.
No, it is not an original jurisdiction, because Article 227 is not an original jurisdiction.
No, your lordship's court is one of the chartered high courts.
Yes, definitely. We have the two divisions, right, the original side and the appellate side.
That is what I'm saying.
And the appellate side is divided into two. One is the appellate jurisdiction, another is the revisional jurisdiction. And Article 227 applications are always regarded as under the revisional jurisdiction.
Almost akin to revisional jurisdiction.
So 115 and the 227 are brought in one bracket.
Yes, almost.
This we got the post 2013.
13,
so
rather
in 2013, your lordship will find that kind of
13, and it is more important.
227, we are concerned with 227 also. No difficulty. We can convert it or we can treat it under 227.
The prayer I am right now making, your lordship did not take much pain, because it can be disposed of by a trivial issue. Resolution of the issue. Issue is very trivial. Blood 39.7 application rejected in a suit for declaration. Now 2011 it was rejected. Where in 2020.
Nothing. Now what is the stage of the suit?
Suit is pending, having been stayed in another connected different petition here before this summons.
Which one?
That is the WPC 9736 of 20.
Give is listed today?
No, not.
Hey, give listed. Yes. I have a very strong view. No stay against an order under Order 39 Rule 7 or Order 26 Rule 9 should not be stayed.
But that also has become infructuous. This 2012 matter has also become infructuous.
Suit has gone or is still pending?
Still pending because of the.
So give that number. Both of them will be listed next day.
But only not next Friday, because Friday I'll go out. Next Friday, with anticipating vacation, I have already booked my tickets to go away.
Yes, it is submitted that again.
May I please address? I have no instruction from the client since many years, but from the e-court's website, I found that the suit has already been disposed of since
Then it has
1st
become
May
infructuous.
2024.
When?
1st May 2024. Suit has already been
It is
disposed.
submitted by the advocate and record of the
No instruction.
So let me dismiss.
But
When you get an instruction, then we'll.
Our instruction is that the final decree proceedings are already over.
This is the partition
Arises
suit.
out of
This is the
partition.
partition suit. Final decree, the partition commissioner's report is accepted.
This was against one of those interlocutory orders where commission was asked to effect partition. Against that, they have come up. So I believe nothing remains.
What? What was the nature of the interim?
The commissioner was deputed to effect partition and to carry out the allotment of shares.
No,
That order,
he
my
is
lord, was,
challenging which order? He is challenging an order dated 16/8.
my lord, 16/8.
The ex parte preliminary degree.
No, originally it was ex parte, but thereafter she has filed for her share has also been allocated. And if your lordship sees page 11, last portion, page 11.
So her share along with her sister and the brothers are already declared in the preliminary degree.
Yes.
So.
And our instruction is probably because of those Asian resurfacing period, the interim order lapsed. This has come almost after 14 years. So the thing has, but then
why he wanted a the stay of the entire proceeding? Because any challenge is made to a preliminary degree.
No, the full stay wasn't there. It was that the execution may proceed, but further signing was stopped by this court.
Signing was stopped or prevented from passing the final decree.
No, your lordship may see order dated 6/9/2011.
Where it is?
6/9, order number 4.
I do not have.
Order number 4 dated 6/9/2011. That's PDF page 2. Page number 2 in the PDF version. Page number 2.
No, this is the impugned order. I have seen order number. You were talking about something else.
No, I was talking about the interim order passed by this court at page number 2. Order number 4. Final decree in CS number so and so may continue, but decree shall not be sealed and signed.
Is what do you say?
I have no instruction.
Your lordship may dismiss it for default if that's what he wants.
Have you contacted your client?
Yes, my lord. I could not contact it. Yes, no.
Is she participating in the suit?
No, my lord. Our instruction, it is over. So what fell from the honorable court at the beginning, your lordship may dispose it of as uh, uh, non-appears or maybe dismiss it for default. And if they have anything, they can revive it later on.
Where is their application? Let me see the nature of the order.
My lord.
The application which is, oh, I can't read. Annexure 5.
My lord, it's in ODI.
What is the relief?
Relief, my lord, would find that at page number 10, what was prayed for in their application, my lord would find it at page number 10. That would be PDF page 19. 19.
That is the part of the order of 16A.
Yes, my lord.
Yes, I'm looking at it. It is contended by the petitioner.
My lord.
That ex parte order has been passed against her in the original suit, and she has filed a miscellaneous case
to set aside the ex parte order. But on 5/1/11, order has been passed by this court for deputation of the commissioner to effect partition of the suit land between the parties. So this is
what has happened to the order 9 rule 13 application.
That instruction.
So you go and apply for stay in the miss case, not in original proceedings. You can't.
But in effect, what the trial court says is that she would not be prejudiced by the deputation of the commission. So in all probability, it must have been all sorted out.
Whatever. The instant revisional application.
No,
You don't
that
know.
we don't.
Any actual. Oh, what else it?
Yes.
Please.
Item 6, my lord. You'll also may dispose it of because, my lord, the suit was in the suit. I have filed a petition saying that the similar issue is pending before this honorable court in second appeal. In the meantime, second appeal has been disposed of, and that was in my favor. On the basis of the finding by the both the courts below that I am the son of my adoption was rejected, therefore this present suit was filed. So now your lordship can dispose it of.
Infructuous.
Yes, my lord. My lord, infructuous will affect, my lord.
Why?
Your lordship may say since the RSA is disposed of, therefore there is no need of.
That is what. Then against which order you challenge?
My lord, I have challenged the order of section 10. Stay of
or stay of the
further
latter
proceedings.
suit pending the former one.
My lord.
Then that was rejected.
Well, that was rejected.
And ultimately, both the suits have been decreed, or
no. The second
latter suit is decreed, or former suit is decreed.
Former suit was decreed.
Decreed.
So
Latter
therefore,
suit is still pending.
Latter suit is still pending. Out of which this petition is paid.
Against the judgment and decree, the first appeal was filed.
Filed, then second appeal.
Second appeal disposed of.
Second appeal disposed of.
In your favor.
In my favor.
Second, and the latter suit is pending.
Latter suit is pending.
You have filed this application in the
latter suit, my lord.
But their application on section 10 was filed to stay the subsequent suit till disposal of the second appeal pending for this court. Now the second appeal has already been disposed. Therefore, the application is infructuous.
It has the
For 7.
Number 7, matter has been called infructuous. The suit is already dismissed.
It is submitted by the counsel for the petitioner.
Number 1, I have submitted a small note, my lord, that
What for?
discussion.
Item number 7 or 8?
8.
8. Where is the petitioner?
Yes, I am.
Which order is under challenge, sir?
Lord, next one is the order.
Is under challenge.
Is under challenge.
Just 1 minute. Let us hurriedly go through the order.
Fine. Order dated 15/4/2008.
Is in execution proceeding.
In the execution.
Order 21, Rule 32.
My lord.
Injunction, enforcement, or restitution. What?
Injunction.
Injunction.
Decree
Yes,
for
let us see.
injunction.
Let us. You are a judgment debtor.
I am judging.
Wonderful. How you came into possession?
Lord,
you have suffered a decree for eviction.
I have suffered
The
a decree for
bailiff went there,
injunction, my lord.
bailiff went there, executed the decree, the possession was given to him.
Lord,
And
decree-
you could
the-
not succeed in the High Court.
No, my lord, the decree, nature of the decree is for injunction restraining not to come over the land.
Not
The
to?
nature of the decree, your lordship find from page 25.
Yes.
I am permitted to place, my lord.
What is the nature of the decree ultimately?
Permanent injunction.
Permanent injunction what? Interfering
Not to
with their
interfere
possession?
with possession.
not to interfere their
Yes.
position.
Yes.
Now they filed an execution under Order 21/32,
Yes, my lord.
alleging that you have interfered with the position.
Yes, that has
The
that
court has directed
no, my lord.
the bailiff to give him a position.
Possession has
He was
already been
given a
delivered.
position
The position has already been delivered. Your lordship find it at
by
Annexure 3.
by you to him.
Yes.
By you to him.
Yes, by
No
me to
difficulty.
him, by the court officials in presence of the police.
That
Annexure
is what
3
I'm
have it.
saying. Then why you came back in possession?
That is not that I am not in possession of the property.
Then who is
Again,
in possession of the property?
He is in possession of property. He has transferred the same to another person. That shall did I have annexed?
Maybe, sir.
Yes, my lord.
Whatever he will derive the benefit of the decree, it will inure to the benefit of the purchaser.
Yes, my lord.
You can't say that he cannot.
No, my lord.
But
my
the thing
submission
is that somebody else than a purchaser is found in possession.
My submission, my lord, only one full, my lord. Once the decree has been executed due to process of the court,
yes,
and property has already been delivered.
Supreme Court judgment is against you.
Yes, my lord. But so far
97 Supreme Court, it says why he should be dragged to another. It will be giving a premium to an unscrupulous litigant to violate the
Lord, I concede to that aspect, my lord. But so far as the decree is concerned, once it is executed through the process of the court,
Sir,
can he again file?
Permanent injunction.
Yes, my lord.
It is, what is his validity period?
No, my lord.
Years.
No, my lord.
Any decree.
Decree for injunction, no
has
period of
a
limitation.
validity period of what?
Decree for injunction, no period of limitation, my lord. He can
Any
execute
decree.
the same. But so any decree, my lord, 3 years.
Any decree 3 years.
Yes, my lord.
Let us see under the Limitation Act. Let us see, sir.
For injunction, my lord, there is no period of limitation.
Let us see.
Here, my lord, the present petitioner has only grievance. Once it has been executed through the process of the court, can he again file execution to oust the party who is in possession of the property? And the trial court has allowed the same.
Article 136.
Yes, my lord. I'm not.
Article 136. For the execution of any decree,
My lord.
other than the decree granting a mandatory injunction,
Yes.
here is a permanent injunction.
Yes, my lord.
Or an order of any civil court.
My lord.
12 years. When the decree or order become enforceable,
yes,
or where the decree or any subsequent order directs any payment of money, that we are not concerned.
my lord.
And it says that for enforcement or execution of a decree granting perpetual injunction,
My lord.
shall not be subject to any period of
Yes,
limitation. So any violation
yes,
during the currency of the decree
Lord,
constitute a fresh cause of action for execution.
Well, Lord, my grievance is, my lord, only that so far as violation of the injunction decree is concerned, he has levied execution proceeding and already has been evicted.
Correct. Now,
Once that be so,
again there is a violation.
Then, my lord, he has to
during
file
the
a
lifetime of the
subsistence of the injunction decree.
Let us see what is the remedy.
He has to file
for the decree.
File another
Further
suit. And file
that means a further decree.
Yes, my lord, further suit for eviction.
Wonderful.
My lord, so far
Against the
136.
spirit of the Supreme Court judgment, sir. You are arguing against the spirit of the Supreme Court judgment. AIR 1997 Supreme Court, you are aware, which is relied.
That is what my submission is in all in this petition law.
I'm sorry,
And
you are arguing against the Jayadayal's judgment of the Supreme Court. What can be done?
This is what my submission, not that.
And you succeeded in dragging this particular proceeding since 2011.
No, he is in possession of the property. I am not in possession of the property. Thereby, I am.
Are you sure that
Yes,
you are not in possession?
No, madam.
Can we appoint a special officer? He is in possession or you are in possession?
Question has been delivered to me again.
Again?
This proceeding. By this proceeding, the last page of the order.
No. Then he has challenged this order. Is there any stay order passed in the proceeding? Yeah.
No stay order was there. Therefore, no stay order was there.
So you have got the position.
Yes, sir.
No difficulty. Should I record?
Yes.
Then it has become infructuous. Taco.
A small note I have given that
question has been disposed of or not.
Yes. It's for the what is this? What is our proceeding?
Take instruction whether the suit in question has been.
What is the nature of the order impugned in this?
Suit is for permanent injunction. My application to status in the order of ex parte was rejected
Under Order 9 Rule 13.
Order 9 Rule 7.
It was ex parte decree.
Ex parte order me. I was said.
What is the ex parte order?
I was said ex parte.
So there is something which is passed against you, order or the ex parte decree or an ex parte order. What?
I was said ex parte. Subsequently, thereafter, I filed my written statement, telling therein to accept my written statement and.
Oh, you were set at an ex parte, and the proceeding was continued against the other defendants.
Yes, sir. No, ma'am. I was the defendant in the court below.
Single sole defendant or
there are 3 defendants.
Correct.
I have
so other 2 defendants?
They also participate in the proceeding.
So they are contesting.
Madam. In the meanwhile, I filed my application on the 11th date of hearing of the case. I was prevented by sufficient cause not to file my WS, for which I filed my written statement in framing therein.
When the summon was served upon you?
That
you know Order 8 Rule 1. You are conscious.
Have a glance to an extra 5 minutes in which it will be very much clear that
whatever is there, if it is there, then if the summon is already served, then
true it is. But after knowing the fact of the order of ex parte, I filed my application to set aside this same and to accept my written statement. It was rejected, and there against that order I have comment.
Now I am asking you a very simple question. Now let us consider if the summon were served upon you.
I was.
Then written statement after 90 days we have to consider what to do. Take an instruction? I don't think so. It should have. 10th.
Item 10.
And
wait, please, Your Lordship. Your Lordship, here I am challenging the order passed by the learned civil judge.
19th of November 2011.
Your Lordship, in rejecting
Just
my petition.
Give me 1 minute.
Your
Order
Lordship.
36 Rule 9.
My Lordship.
For investigation, Commissioner.
Your Lordship. Because the.
What is the nature of the suit?
Suit is for, Your Lordship, declaration of my right, title, and interest for permanent injunction restraining the defendant from possession of the plaintiff. Also for the mandatory injunction, since they, by encroaching over the suit land, they have made some thatched house.
So,
and also for
there appears to be a bounded dispute.
There, Your Lordship, I am grateful. Lord.
What defense they have taken?
Your Lordship, since they have denied that we have not encroached over the suit land, so therefore I filed a petition under Order 26 Rule 9. That was rejected by the learned trial court only on the ground that the suit is for declaration of title. And therefore he rejected my petition, Your Lordship.
So it's the declaration of title means the rival title has to be gone into.
Your Lordship, the dispute essentially is a boundary dispute. Your Lordship. Your Lordship may come to.
Where is the other side? Service has been affected. Huh? Is there anybody appearing? Was there direction for service?
Your Lordship, by order dated 3/1/2012.
Can you inform Mr. P.K. Panda?
I will, Your Lordship.
10th we are keeping.
Yes.
Okay. Item 11.
In instructions that the matter has become infructuous.
Because submitted that the matter, the instant writ petition has become infructuous. Accordingly,
I tried to contact the client, but the phone
number does not exist, so I'll send a registered post letter, my lord. For this, my lord, time may be given. No instruction has been given. Whether they are alive or not.
Card and all, everything has not been received.
No, my lord, all the defects I have removed, my lord. In my record, it is written.
Item number 12. Yes, sir. Neither ED nor undelivered notice from opposite party number 1 to 7B.
Yes, ma'am.
Till now, but that is not there. I'm just looking at this. Come on, 10th. Let us see. 13.
Item 13.
A small point is involved.
Small.
Very small point, but it's a crucial point.
Crucial.
The fact of the case is.
What is this? You are challenging which? You are challenging which order? First, tell us.
Annexure 3.
Annexure 3.
Not the order, only one direction.
7-5.
Yeah.
Where is that order? 7-5.
17. Page 17.
2014. 7-5.
Order is.
I'm unable to get it.
Page
Sir.
20.
Page?
Page 20.
Page 20 is a order dated 3/2/2014, sir. Seven 5/2014.
Page 20, you will also find that is the judgment passed by the.
Sir, 17/5/2014, there is the date of degrees drawn up and notified today.
Copy of the order dated 7/5/12/14. That is the order of the Learned District Judge allowing my appeal on the basis of compromise, but giving a direction that this compromise will be effective only when you registered it before the registrar.
That is what is the partition suit.
It was suit for declaration of title and also possession. I lost it. As the plaintiff came up with the suit that kindly declare the title so far the land is concerned because I have purchased it. Court said purchase by way of oral sale or through a unregistered document are not granted it. So accordingly dismissed it. I prefer appeal. In the appeal, matter was compromised. In the compromise, he admitted that compromised person, if you will peruse, that is at page 17. He admits my position since the time of oral sale or through a unregistered document. So when this was admitted and compromise was effected, court said that so far as the compromise is concerned, there is no impediment because it is illegal. So decree is accordingly passed on the basis of compromise. So far as the effectiveness of the decree is concerned, it has to be registered with the registrar. That is my challenge. What I say, my lord, if beyond this,
sir, can it be done in this forum?
In 227, only in 227. I had filed accordingly 227. I initially filed.
What to do? Order 43, Rule 1, capital A will not come.
It is not necessary because it will.
I am asking you, sir. Order 43, Rule 1, capital A will not come.
Will not come in this sense.
Read it, sir. Why not it will come? A.
May I get the book, my lord?
Yes.
Because I am not challenging the decree. I am not challenging the judgment.
Please. Or why not 151 be applied there before the appellate court?
151.
Because order 23, rule 3A is a power of a suit.
151 can.
Look at it, order 43, rule 1, capital A.
And appeals are lied from the following orders.
No, that is one.
That is
I'm
one.
talking about 1A, letter on
1A, an order
not
under
small a. Rule 1A.
Milord. Rule 1A,
Please turn the page.
page 217. An order under Rule 10 of Order.
No, you are reading order 1, order 43, rule 1 you are reading and sub clauses. I am saying rule 1A, capital A.
Oh, capital A. Right to challenge non-appealable order.
Please.
In appeal against decrees, where any order is made under this court against a party, and thereupon any judgment is pronounced against such party.
I'm talking about 2.
In an appeal against the decree passed in a suit.
It is after recording a compromise.
Or refusing
Your
to
case is
recognize
after recording a compromise.
to contest the decree on the ground that the compromise should or should not have been recorded. I'm not on this. I'm accepting compromise, accepting the order, but I only
should or should not, when it means the portion of this should not have been recorded. You are challenging a portion by directing
says that no.
And then you say recorded means he's saying that you go and get it registered under the Indian Registration Act. You are avoiding the stamp duty actually. Main purpose I understand.
I can avoid because of 17. Section 17 says if the particular property is within the scope of the suit and a compromise is arrived at or a decree is followed, that I need not go for registration. That is clearly that is the statute.
What is statute?
17.
What? Registration Act.
Registration Act.
What it says, it's a compulsorily registrable documents. Section 17 is only relatable to a compulsorily registrable document.
Yeah.
Which are the documents which are compulsorily registrable? So,
I admit
what
that.
it says.
So any RSD beyond 100 compulsorily registered.
That is under the Transfer
That is also
Property Act.
Milord.
It says any immobile property fetching a value of more than 100 cannot be transferred unless there is a bilateral document or a written document, and then Section 17 makes it compulsory.
And 17 says a decree when executed, if in that decree certain property.
Yes, sir. Please tell us.
I have quoted my appeal memo.
Please. A registration act. Indian registration. Yes, sir.
I want to come to 6. 17.6.
Yes, sir.
Any decree or order of the court, except a decree or order expressed to be made on a compromise and compromising immovable property other than that which is the subject matter of the suit or proceeding.
What?
So if it is within the subject matter of the proceeding, then it doesn't require registration. That is the mandate of the Honorable Supreme Court reported in 1997. That judgment, 96, that judgment I have got. They have distinguished 7 instances they have given. They have made distinctions, and 4 types of cases they have also explained that these are the situations where no such registration is required. My stand before my lord is that this particular suit property is not beyond the suit property claimed. So if I get a decree over the suit property, I need not register it. If beyond the suit property I am making a compromise in respect of some other properties, then compulsory register. That is one aspect. Second aspect is, my lord, when under 17 I am not required to register it. And also, Supreme Court has discussed this. And also,
Sir,
transfer is
there-
not there.
Please, there are distinction. There is a distinction. Please come look at 11, the section 17. You have what it says. Subsection 1, I am reading. The following documents shall be registered if the property to which they relate is situate in a district in which, and if they have been executed or on and after the day of the Act of 1864 or an Indian Registration Act or the Indian Registration Act of 1871 or 77, namely, then come to B.
Right.
Other non-testamentary instrument. No difficulty. Compromise is a non-testamentary instrument.
Right.
Which purpose or operate to create, declare, assign, limit, or extinguish, whether in present or in future, any right, title, or interest, whether vested or contingent, of a value of 100 rupees and upwards, to or in immovable property. So one has to consider the nature of a non-testamentary document which declares or limits or extinguishes your interest in the immovable property, which is more than 100 rupees. Correct? Then come to 2, subsection 2. Nothing in clause B and C
of subsection
of
1.
Subsection 1 applies to. Then come to Roman 6.
Yes.
Correct?
What I read.
Any decree or order of a court, then except a decree or order expressed to be made on compromise and comprising immovable property, other than which is the subject matter of the suit or the proceedings. Now, this except has to be understood so far as the compromise and comprising the property is concerned. You can enter into a compromise under Order 23, Rule 3, no problem. Even the power is extended that by virtue of compromise, you cannot restrict yourself only to the property which is the subject matter of the suit, but also include many other properties.
Additional property.
No difficulty.
No.
So this says that a decree or order need not accept when it is on compromise and comprising the subject matter other than the suit. I understood. I'm a very good reader of your body language. Don't worry.
First time
When you become so skeptical, I thought that what you are going to say. Now, second thing is, first thing is the compromise. Correct? Compromise. There are two views. Is the compromise affecting the rights of the parties will be regarded as a decree passed in a normal suit, or it is a recording of an agreement which the parties have entered into, which requires the registration.
If it is in present title passes on
or in future.
No, future.
Why not?
Future is different. But if title
Deed of settlement, I am giving you a deed of settlement.
Yeah.
Please consider. You say not future, then I am a deed of settlement. Why not? Deed of settlement, deed of contingent gift.
So far as succession.
Why not? That is in future.
Succession Act, you will know.
No.
If
Succession is the testamentary. I am not talking about a testamentary instrument. I am talking about non-testamentary instrument. I am conscious of the testamentary instrument. Don't worry. But non-testamentary, what will happen? Transfer of Property Act says that you can transfer your right, title, and interest in respect of immovable property either in presentee or in future. If both are the incidents of the definition of a transfer of property, why not? Past you cannot, no difficulty.
My
But
view
in
is-
present and future,
my
why
view
not?
is three things have to be taken into consideration. You are going to sell away some property exceeding 100.
Correct.
This act comes to play. PP Act comes to play, saying that if
No
more
difficulty.
than 100,
Correct.
that compulsory.
Correct.
Because alienation is on that particular date.
No, if you come to Transfer of Property Act, it says that the transfer can be effected either in presently or in future.
Or yes, present and in.
I'm giving you the several examples. The deed of gift, the deed of settlement. The owner during his lifetime can settle his property. And in the deed of settlement, it says that I would remain the owner. I will exercise all my right, and thereafter it will go to these son, wife, whatever, the daughter, whatever.
That
it
is
will
not
go.
compulsory. It's a will.
I am coming.
Will, is not compulsory.
I am coming. After all, it affects the transfer. You are really conjointing 17 with the others. Only thing is we have to segregate it. The transfer of the property either in present or in future. Say contingent gift.
Contingent not registered.
Why not?
Because
why not?
In contingent,
yes,
this will develop on you.
Absolutely.
Like will, not compulsory.
No. Why not? Contingent. I give you, and bequeath you, or I gifted you a property.
Your contingent comes only in a case of will.
Happening of the event.
Happening of the event.
This is a
And
gift.
also, on my death, it will develop on you.
Does it require a probate to be granted if
That
it
is
is regarded as a will? No.
No.
Contingent gift, section 123 or 124 of the Transfer of Property Act.
That view,
No. Onerous gift, if it is, why not?
onerous gift compulsory.
Why not?
And so far as this particular case is concerned, I am not examining those laws.
Yeah, that's why the
so far
first
as
and
this
foremost, sir,
concerned-
first and foremost question is the nature of the compromise decree.
nature of problem.
If the nature of the compromise decree postulates the declaration of the right for the first time in you, or
Then we'll go to-
extinguishing of the right
Then we
in
shall go
respect
to
of
compromise petition. In compromise petition, acknowledging my previous position, saying that you have already acquired a title
by way of adverse position.
adverse.
Thank you.
That is the compromise. Court has said that it is legal. If your lordship will strike down that compromise itself, then I do not know.
No, I am not here.
The court
Sir,
said
I can't go beyond it. Only thing is restricted whether it is registrable or not registrable.
it is bona fide compromise. It is in accordance with law. So I am accepting that so far as the government's made the compromise is concerned, that he is acknowledging my title since the date of purchase, but because it was under a plain paper, the trial court refused to grant me decree. Appellate court, there was a compromise. Both the parties came to court, filed their compromise petition saying that I acknowledge it. It is in English. Yours can
Is an unregistered document.
compromise. That's
No.
what the
They said it was unregistered.
That is why court refused the decree. So I prefer appeal. And I kindly appreciate at page 17 that the respondent the opposite party admits that the appellate
Oh, sir.
has
I don't think so. There is anything which requires adverse position. Sorry.
They are poor people, my lord. They will again go.
No.
Your also
Sir, by virtue of the provision of the Limitation Act, you are taking a property admittedly belonging to another.
I refer
And
to
this
certain
is-
decisions.
Please.
I beg
Go
your
on, sir.
lordship to appreciate your lordships are accepting a court's decree so far as partition of the properties are concerned in view of the new legislation that unless if you show there is a partition, then it will rest, not rest on the daughters. You have prior
No, I could not get it. What you are saying?
now the legislation is that daughters are co-persons,
Correct.
but if those co-personers prior to coming up this enactment, person is already affected, your lordship will give effect to that person deed provided that person has been registered or there is a court decree. That will be honored.
Sir, I do not know. I may be wrong.
If
You
a
are
court
talking about
decree, I need not go to
no,
registry.
you are talking about the codification of a Hindu law which was effected in 1956. Before the codification of the Hindu law, now there are two principles which comes. One is the Mitakra and another is the Daibhaga. So far as the Daibhaga is concerned, the woman right was always recognized. The daughter inherits the property of his father. So far as the Mitakra is a
on death.
Not on death. Is a male who is to inherit, is a male who has to inherit. After the codification, the limited right under 1923 Act of the woman has now become an absolute right.
Absolutely.
There is no difficulty.
No difficulty.
So this limited right converted into an absolute right. Exception is section 14(2).
I am not on
Not on that.
I am only on a point.
Now I am coming. So once it becomes an absolute right, then the only inhibition which was there is old section 23 of the Hindu Succession Act, where the female were debarred from filing a suit for partition of the father's ancestral property. They were debarred. Unless the male chooses for a partition, they were not. But they have to be implemented as a party. Now that 2005 amendment deleted. Now the women can also come and file a suit for partition. Now, in a partition suit,
not on all those. I am
in a partition, I am coming in a partition suit. When a final decree is passed, where these shares are separated by meets and bounds, does this final decree not require to be engrossed on the stamp paper? Does it not require?
It is required.
Without engrossing on the stamp paper, what is the stamp paper?
That decree becomes
that the highest share, the value of the largest share has to be taken into account. On the basis thereof, the stamp duty is to be given. No difficulty. So in that event, if it is engrossed, what is the nuances that the government should not lose his exchequer?
Because I am not on those points. My point is that your lordships are accepting the proposition that so far as the right of the co-personal, daughter co-personal, which has come by a substitution amendment in the 2005 amending act, there your lordships are accepting the partition. That there was already a partition, you have no share.
No.
Even if you are a co-personal,
No, that was you are taking into consideration the pre-amended Hindu law, codification of the Hindu law, where the co-partners after his death will be deemed, there will be a deemed partition of his shares and will be separated therefrom. Here also the concept is that the moment one of the co-partner died, be it a female co-partner or the male co-partner, then her share would be deemed to have been separated. That is under the Mitakra school. Not in Daibhaga. I think this reason is governed by Daibhaga.
So far as
this reason is governed by what?
Nobody has any share.
Daibhaga, I believe.
Even in ancestral properties.
Daibhaga or Mitakra?
Mitakra, your lordship. So far as Daibhaga is concerned,
because the entire Bengal is governed by Daibhaga. That's why I'm saying the greater part of it.
I also belong to Daibhaga. I am a Bengali. I belong to that.
That's true.
So far as my father is there, I cannot claim an inch.
Though I am, but still governed by Mitakra. I do not know why.
I am not on those. So perhaps I will not be able to make your lordship understand what I felt. I felt it proper that If a court decree is there, already you have got a title. Why will again go and register it, get it and spend money? No.
Again, I'm
Leave that
saying
Narasingh
that is why I say that is a declaration. When
should I pray for another adjournment?
after such a
No,
intensive interaction,
we cannot compliment the judge, but we will be obliged. Today, for the first time, I am attending my lord's court, but after sitting for half an hour, I thought that such a brilliant.
No.
That is my feeling.
No.
Such a brilliant appreciation.
No.
The moment the case comes, you have to
No.
find it. That is my.
No.
If you are also take in
I
passing
think
order,
in Calcutta the dais has that particular the carpet which makes it non-skid, but here it is not. So it will be very oily and the skid will come. Don't do that.
That was my feeling. I explained. Your lordship will go through these judgments. My lord, kindly read page 1295. The legal position, qua clause 4, 6, Registration Act. They've dealt it.
Just one.
Avoid that.
Sir, this judgment is a double-edged sword, sir.
Here in the similar line, there is a
It
judgment
is
of
a,
the
it
Honorable
is a
Court.
double-edged sword, sir.
Double-edged
You are,
sword.
you are.
Yes, yes, yes. No. I
Are
understood that. Double-edged. But still then, if your lordship will prefer to examine another judgment of the Honorable Court in similar line, but that is not double.
Not.
No. Our High Court judgment favors. But I couldn't get that.
But we are bound by the Supreme Court judgment. Give.
Double-edged can be, but in strict sense, if your lordship will have solace my lord's pen to this poor people. Those are
No, that's the law does not make any distinction between a poor people or a rich.
Always we have distinguished.
No.
Even Supreme Court
Is a
judgments are
law does not. Law does not. Is a neutral.
And that will pour into or
Only thing is the approach. That's the different.
I leave it to my lord.
What is the other?
Some solace to poor people, they will again go and spend huge money, even though God got the title from the court.
No, it will relate back to the date when this right is perfected.
Right was perfected a long time. 69 was purchased. Suit in the year recent suit. 69 was purchased. So if it will relate back to that time, already perfected by prescription.
No. How prescription?
Indian also will
Why prescription? By virtue of adverse position.
Adverse position, my vendor,
So you did not. The first and foremost principle which struck me was that if it is a creation of a right for the first time, then it requires a registration. And this is what a registration of a right into you by virtue of a contract.
That you are saying that I can construe it, that title starts from today. In that case, I have no case. If the title start, that is why I also I finally see 1987 2LR, that book I couldn't get it from my, it has been stolen or something. 87 2LR. If your lordship is of the view title starts flows from today, because you are getting a compromise, then I got notice. But if my vendor is acknowledging my title since the inception of that letter or that,
then it opposes the concept of the adverse position.
if adverse person is there, your lordship may say that it is not presentee. It is years back. In that way, a poor client can be said. I don't say that it will be a binding precedent, but considering these aspects.
Very difficult, sir.
Difficult because it will be a landmark decision. It may affect others. That is why your lordship is not interested. But I pray your lordship should distinguish saying that it is not a presentee. Title doesn't flow presently or today. It was from the very beginning, which he is admitting. In that way, your lordship can distinguish.
Can it be? Because give me a transfer of property act. The definition of
May I
transfer of
pray, let it come some other day. Well, it's a
you
different
need the definition of a transfer of property under the act. Can he?
No,
Section
I
5.
Today I have not taken my lunch even.
Don't worry, we are on the same footing.
I pray let it come someday because bar is also there. They will assist. It will
Section 5.
Yeah.
Section 5. Can it be transferred in past?
Present in future. But by a document. Here by a decree. Section 17.
So it is the date of the decree which is important.
No, here decree word is not.
No.
When? In present or in future.
That is what I'm saying. Past is not the transfer of property.
So your lordship is in my favor.
thinking that on the date of the compromise decree, not prior thereto.
Then it is present.
Has to be. Has to be.
But your lordship may also say that vendor is acknowledging my position since that date, and also saying that yes, I already the right has accrued. Flux of time adversely I am.
There are elements which has to be proved. This is a compromise, sir.
I leave to my lord.
Hostile, continuous, uninterrupted. All are the incidents of the
when he is admitting, not necessary. Had he not admitted, he admitted.
mere admission of a possession does not mean it becomes a
Admission decree can be passed.
Huh?
On admission decree can be passed.
Order 12 Rule 6 can be done.
So long as it's not illegal. Illegal.
Anyhow,
if your lordship wants it, second argument, because bar is there, they will be interested also.
What? The bar is not a.
It will be a landmark decision come to use for everyone. Bar members, judges.
I do not know. I think it is a well settled.
Your lordship go to that our High Court decision.
No, I have not.
If that, because
You give that and bring that book.
Taken beyond that decision, then it will be.
You have the copy of the judgment of the.
That judgment I could.
You just give me a citation. I will take.
Citation I have already. It is quoted in my memorandum of appeal.
Give that. I will consider that. Don't worry. If I find yes. If I find that I am not agreeing to the proposition, and if it is a coordinate bench, then I will refer the matter to a larger bench. Don't worry. But I will take into consideration that judgment.
Because I have written that doesn't create any interest in the immovable property in the present. The document is not required 17 of the similar view of our High Court in a decision.
Let us.
I must have read that decision. Otherwise, I could not have.
Don't worry. I will read every bit of it. Don't worry. Yes. Call the next. I can continue. Let me dispose of this.
I beg pardon, my God. Item 17 is infructuous, madam.
Item 14.
We are continuing with this. I will dispose of these matters. Then arbitration I will take up on the other day. Is 14.
Item 14.
Item 14, I am appearing for the opposite party number 10, who has already died during the pendency of this CMP lordship. I am submitting a memo.
That I have to take substitution, lordship, because his section 10 application has been rejected. And the section 10 applicant is defendant number 10 who died.
So
they have filed an application that
it is submitted by the council appearing. Steps.
Item 15. Item not 15.
Yes. Who is appearing? Yes. Administrative notice is given. To the petitioner. Has it come back? Yes, there is an order. What? Huh? After valid service, receive back. Report of the processor. Flag A. What is this flag A? Madhu, is it about? What is written? Nothing appearing for the 30th November 2015 are hereby quashed and set aside.
Moot has been dismissed since long, and would be petitioner and of the party are directly. I'm filing the
It is submitted that
I'm not the opposite
not
party.
only the suit has already been disposed of, but the parties here too are also no longer in this world. Stop. In view of the above. There. Yes. Why you are asking? He is appearing for whom?
Mr. Ellen Patel. Mr. Ellen Patel.
For whom? Petitioner.
Petitioner.
10th.
Item number 19.
19.
Item 19.
Oh. Don't know. Yes. Dismiss. Next.
Item number 20.
May I please, Your Lordship?
What is the order impugned?
Order impugned is Annexure 4 of the
4.
Annexure 4 order
Just give
written.
me 1 minute time to hurriedly go through the order. Just 1 minute. Give it. Who is for the other side?
Mr. Pradhan is dead, and I have informed his associate, Mr. Mahapatra. Last
Can you
occasion.
secure his presence?
I have
on the
informed.
next day?
I have informed him in last occasion regarding listing of the case.
Because I feel the order needs interference. So his presence may be, should we proceed ex parte? Because the wrong principle has been applied. If the issue is decided in affirmative manner, then why not the ultimate relief should also be given? This is your case.
That's why the judgment needs correction.
So even
Accordingly-
151 is applicable.
Accordingly,
152 is there, no doubt, but omission is also one of the ground.
yes.
you secure his presence on 10th, first matter, even. But you just give a notice so that on the other day you just file a notice and yes.